Most injured workers are protected by state workers' compensation systems. Under these programs, employees make a trade-off. They don't have to prove their employer's action or inaction led to the injury, but in exchange, they sacrifice the right to sue for damages. That is, the injured party does not have to show employer negligence to receive benefits. Thank God, things are a little bit different for those who work on the nation's waterways or railroad lines. Unlike workers' compensation, the Federal Employees Liability Act, which covers railroad workers, is not a no-fault system. Neither is the Jones Act, which protects workers who serve aboard water-going vessels and was modeled on FELA. Under FELA and the Jones Act, negligence matters. FELA and the Jones Act reject the common law doctrine of contributory negligence in favor of the more employee-friendly system of comparative negligence. On December 9, 2012, Greg Gibbons, an employee of Union Pacific Railroad Company, was hauling equipment and supplies for them through a canyon near Caliente, Nevada, where he was severely injured. In order to reach his destinations, Gibbons had to traverse a homemade railroad flat car bridge on a Union Pacific access road, both owned and maintained by Union Pacific. This bridge was actually an old pre-World War II decommissioned railroad flat car built in 1941, taken out of service in 1963, then repurposed as a bridge by Union Pacific. Union Pacific does this because it's a low-cost alternative to constructing proper bridges. The bridge spanned about 100 feet and was suspended approximately 15 feet above the canyon floor. Now, using railroad flat cars as bridges is generally considered not safe because they are not designed for that purpose, lack proper structural integrity to support significant weight distribution, and can easily fail under heavy loads, especially when not properly supported or maintained, making them a significant safety risk. These flat car bridges are unregulated by the Federal Railroad Administration. Union Pacific never assessed the weight-bearing capacity of the bridge, but they should have. There was no evidence that this flat car converted to bridge was ever designed to hold this capacity. And more importantly, they never posted warnings as to the bridge load capacity or risk of collapse. Flat cars lack safety features because they are essentially bridge components, like guardrails, proper abutments, and load-bearing reinforcement, increasing the risk of vehicle or pedestrian accidents. On this day, Gibbons was driving a dump truck carrying rocks and towing equipment with a collective weight of over 100,000 pounds. As Gibbons crossed the canyon, the bridge collapsed into the underlying riverbed, causing serious and permanent injuries to Gibbons' neck and back, necessitating fusion surgery in his neck. His injuries will require at least 2 and likely 3 future surgeries. Gibbons was eventually able to go back to work, albeit medicated, in pain, and with functional limitations. Based on these injuries, Gibbons filed suit against Union Pacific on November 25, 2015, asserting a claim for negligence under the Federal Employers Liability Act. On May 7, 2018, the jury reached a unanimous verdict and awarded Gibbons the following: $1.5 million in lost wages and benefits, $500,000 in likely future medical and hospital expenses, and $1.5 million for mental anguish, and $1.5 million in physical pain and suffering. Not happy with the verdict, Union Pacific appealed. In this new insider-exclusive Justice in America Network TV special, Justice in America, Railroad Disasters Ahead, our investigative team sits down with Greg's lawyers, Brent Kuhn and Jim Morse, at the Brent Kuhn and Associates law firm to give us an update on this case and how to prevent such disasters in the future. This is the Insider Exclusive, live from Houston, Texas. It is my great pleasure to introduce Brent Kuhn again. Welcome to the show, Brent.
It's good to be back. Good to see you. Welcome to Houston.
Hey, thank you. Nice day out today, isn't it?
It's rare in the winter. Thank you for bringing that California weather out here.
So today we are talking about a case that deals with railroad trestles and track cars, that are basically out of service and do not serve as a viable function to bridges. Tell our audience a little bit about this case.
Again, first I have the pleasure of representing the Brotherhood of Maintenance Ways, which is the main union for railroad workers working all over the country on the track. So we get a lot of stories coming back from our membership about the horrors of the abuses of the railroads associated to all sorts of different safety issues. And as you know from the many times we visited before as a public policy law firm, we look not only to help victims of this and employees of the railroad and other areas get some sort of restitution or compensation back on their feet from cases, but we also look for things that are a bigger issue and a bigger talking point that impact other safety considerations to the general public or to the workforce. And what we found out in this case is that there's a very serious issue associated to these bridges. These are homemade bridges. And so what we have found with the Gibbons case, as an example, here's a guy that's been working for the railroad a long time, in this case, Union Pacific. He's just doing his job out there where they're told, we're taking ballast, which are the little rocks on the tracks they use in between all the track, the cross beams that go in there. And so when they go in there to replace those and to restore all that ballast and build it back up, it stabilizes the track. What all of that is guided by and overseen by the feds. The Federal Railroad Administration has the authority to oversee all of the safety aspects of the track itself. What it doesn't do is have any authority over the roads that run parallel to the track that are usually the service roads that the railroad operates on to get to all their tracks for all the repairs. And again, because of the weight of these trains, these tracks have to be repaired all over the country all the time. And a lot of them run in rugged areas and stuff like that. And what we found was that to get across all these ravines and all these other very rough territories that all these tracks run through, they just took their old abandoned flat cars and laid them across these ravines and made them service as a bridge. The problem with that is that these are not engineered to be bridges. They have not been approved by an engineer or anyone else as a bridge. They don't test the structural integrity of the metal when they use these abandoned flat cars. And not only do they use them for their own rail car employees to have to drive over, they also sell them to local governments, municipalities, small towns across USA. They sell them as a bridge that you can buy cheap because it's one that they've already mothballed, and they sell them to them and represent to them that they're of good structural integrity to serve as a bridge.
The Brotherhood of Railroad Workers is aware of all these problems. This is not the first accident that happened.
No, this does happen. Fortunately, it's infrequent, but it does happen. They do know that these are repurposed rail cars, and they do know that they were not designed to be a bridge, and that poses a whole nother set of risks. In addition to that, where they place these bridges, there's no load-bearing test done. So nothing has been done from an engineering standpoint to ascertain how much weight can that flat car hold when you're driving across it. Is it 2,000 pounds, 10,000 pounds, 50,000 pounds? Can a bicycle go over it, or a car, or a truck, or a dump truck? None of that is ever weighed, factored out, and engineered.
What I found unusual is how long is a flat car, generally?
Yeah, flat cars are 80 feet.
80 feet. There's no support in the middle of it. None whatsoever.
People see these going down the road. Usually, you don't see the flat car itself. You see these big boxes. This is the cargo containers that are sitting on top of these flat cars. And as they're going up and down the road, they actually bow up, just like boards. Most people don't know in construction, but all boards have a bow or a little arc that you're supposed to put topside up to hold the weight and support it. If you have a little bit of an arch, it takes that weight and flattens out. And rail cars are made that way. By the time they're mothballed, that tensile strength that has created a little bit of bow to support all the weight that sits on top of it is no longer there. It's been worn out, and now it actually bows out like a swag belly.
Right, and this flat car was manufactured, if I remember correctly, in 1941, mothballed in 1963. Accident happened in 2012.
Yeah.
And nobody had done anything about it, right?
No. And if you look at it with that chronological history, it's like, first of all, what does it mean to be mothballed? This flat car had been taken out of service by the railroad because it was no longer usable, that the tensile durability of that flat car was gone. It was worn out. You can't use it. It's taken out of service because it cannot be used. It is too old to use. And instead of just kicking it to salvage and letting them make scrap metal out of it. They repurposed it and said, you know what? Let's just make bridges out of them. We can sell them and we can use them on our roads. We don't have to pay an engineering firm and a bridge building firm. We don't have to pay them $100,000 to come out and build something across this. We'll just put one of these old abandoned, scrap, mothballed flat cars out there. And they never considered, well, how much weight do they hold? We don't know. I guess we'll figure it out if something goes over it and the bridge breaks.
This is this case, Gibbons case, right? He was driving a truck over one of these bridges, right? He had 100,000 pounds in the truck, I believe.
Yeah, that's that rock ballast, load of rocks on it.
You would think, and this is one of the reasons you took this case on in the first place, that you need change. You do cases because you want to see change made, right? Safety. A lot of your cases are involve explosions, great damage to property as well as to people. Do you see that change happening in the railroad industry?
Zero. In fact, the safety considerations have gotten worse instead of better. There's a lot of lobbyists with the railroad industry. They're very influential in Congress at the national level. They're even influential at the local levels. And they get away with murder, almost literally and figuratively. If you look at the history of the railroads in general, they were notorious, particularly back in the 1800s, of doing anything and everything they could to own everything. And even today, that nostalgic mentality still applies to them. They're still a very strong industry. They're a very wealthy industry, and they have a very effective level in Washington to make sure that there's not the level of regulations that needs to be there. And there's so many loopholes, even where they are regulated. For instance, Congress said, we can't let you run unbridled out there. You take too many risks. So we're going to pass a law full of statutes and guidance called the Federal Railroad Act, and it's going to dictate to you a lot of things you can and cannot do. Well, that's all fine. You can't build bridges for your railroad tracks to run, for your trains to run up and down on these tracks, unless they've been properly engineered, unless they've been surveyed, unless the structural integrity is done on a regular basis, not only by your people, but we have federal agents that are going to come out and check all this stuff on a regular basis too. Well, that's all fine for the structural integrity of the railroad track bridges. What about the bridges they use that run parallel to the railroad track?
Yeah, well, what about that?
There is no regulation.
That should have been brought up before, correct?
It's brought up all the time.
Why does it get shot down?
Because there's not enough impetus in force to overcome the lobbyists' fight against it. The lobbyists in the railroad industry don't want any regulations. To the extent they already have them, they're always trying to erode them, but they certainly don't want to see more of them. The railroad companies on almost every one of these tracks, tens of thousands of miles crisscrossing America. In most of the circumstances, they have to be able to get to that track off of the service road, running parallel to it. Many of these places, you go through the Rocky Mountains and many other places, you are tens of feet, hundreds of feet, even thousands of feet above grade level where you're crossing. The railroad industry doesn't want any regulations over their maintenance of those side roads because it will exponentially increase their cost of operation. So they've done a very good job of keeping the feds out of the whole overview of that. And as a consequence, they can make their bridges out of whatever they want.
You know, in many of your cases, OSHA is brought in. They do an investigation, they do an extensive, how about the railroad industry?
Well, the railroad has very little oversight with OSHA. OSHA goes mostly into fixed building facilities, plants, refineries, office buildings, and other things. There's no oversight of OSHA inspectors going out and checking the railroad. Those are all fixed operational. They don't house people. And to the extent they're overseen through the FRA, it's mainly just structural integrity issues of the bridges. And these are the track bridges. They don't even look at, nor do they have authority to be looking at the structural integrity of all the homemade bridges that they utilize to gain access to their track.
One of the things that impressed me about your client, Greg Gibbons, right, was the fact that he still wanted to work despite his injuries.
You know, these railroad guys are tough. These are your old blue-collar, salt-of-the-earth guys. And I don't know any classification or trade out there that are tougher than these railroaders, particularly the guys that work the gangs on the bridges. You're working in the most adverse weather conditions year-round. You're working in areas very remote. You see the tracks running through the town, that's fine. 95% of the track doesn't run through the town. It's running through the woods. It's running through the canyons. It's running through the mountains. It's running in blistering heat in the deserts. It's running through the snowfall. These guys have to work in all of those conditions all over the country all the time. And they're used to those hostile work environments. and they're used to the railroad pulling them through a lot of knotholes in their job. It's very difficult work, very hard work, and it can be very treacherous work. And for all those reasons, Congress stepped in and mandated a number of specific rules and regulations dealing directly with the railroad because they were so high risk to their own employees.
I'm James Morris. I'm of counsel to Brent Kuhn and Associates here in Burbank, California, where I practice personal injury law on behalf of plaintiffs. What we learned from the Greg Gibbons versus Union Pacific case is how important it is to have a credible plaintiff. Greg, even though he had had a double neck fusion, he returned to work full time and continued to work a very strenuous job that he probably shouldn't have been working given the injury that he had. But he hung in there, worked hard, and the jury appreciated his sincerity and the fact that he was willing to go back to work and not malinger or be someone who just wanted something for nothing. Improving safety on the railroad was the goal all along in this case. What the Union Pacific had done was take a flatbed car, take the wheels off, and then take the bed and lay it across gullies, different types of creek beds, and without testing the flatbed to know how much weight it would hold and how strong it was going to be, they made it a part of the daily routine as people like Greg Gibbons drove large dump trucks with thousands of pounds of ballast in the back, in this case, pulling a backhoe on a trailer, in addition to the thousands of pounds of ballast. And of course, the flatbed bridge collapsed. My co-counsel Brent Kuhn referred to it as the homemade bridge. The homemade bridge collapsed. And the reason it collapsed is there was no sincere effort made to test it to determine whether or not it would withstand the weight. And unfortunately, it didn't. Greg and his truck fell 15 feet down into the middle of the ravine. He blew out 2 discs in his neck that had to be fused. And that's the type of accident that shouldn't happen. And hopefully this sent an alarm bell to UP that if you're going to do this in the future, you have to test these things to make sure they're safe. We have not been advised that the Union Pacific Railroad has done anything to alter the use of flatbed trailers in the wilderness. These are used in remote areas that cars rarely drive across. Primarily, it's just working trucks, dump trucks, and implements that Union Pacific uses in its work. But we've heard no report that they've done anything to alleviate the danger and to make these safe.
One of the things that you had mentioned prior to us coming here and doing the show was you want to see change. How's that going to happen?
You know, we always want to see change. Anytime we handle a case where we realize that it has greater ramifications. This was not an isolated incident where a bridge collapsed just because it hadn't been properly inspected or something. It collapsed because, one, it shouldn't have ever been a bridge. It was not designed to be a bridge. It was designed to carry a box car off of a truck from point A to point B and put it back on a truck. That's all that was designed to do in the first place. Worse than that, once they decided to use it for a bridge over a ravine, there was no testing nor posting of weight. If you're driving down the road and you cross any bridge, you see a sign, and that sign posts what the weight bear is for that bridge. So that if there is something, very heavy industrial or something, or trucks with big loads.
But not on these.
No, they don't have to. There's no regulation for them. Even on your highways, we're used to State inspectors and other people coming out and doing it if the feds aren't doing it. And this is a gap area where it's owned by the railroad or controlled by the railroad, and they get to make whatever kinds of crossings they want out of whatever material they want. No requirement to certify them, to inspect them, to test them, or retest them. And in this case, it was so obvious that when we went out and took the pictures of the where this happened, the bridge that they were using, this rail car, actually had a sway of over a foot from both ends to the middle. And it's supposed to be a bow of a foot. It's like they turned it upside down. And it's like, that tells you something just from casual observation, which is that this rail car has metal fatigue because it's so worn out, it's bowing down towards the ground. So it's lost whatever structural integrity it had, was long gone, which was no doubt part of the reason that that rail car had been mothballed by the railroad 40 years before they put it into service as a bridge.
This case exemplifies some of the protections that railroad workers have under FELA, right? As well as maritime workers under the Jones Act, right? It seems to me that they're a powerful union. And it seems to me that they would want this change, that they would do something to get this changed.
That's a very good point. The railroad knows the limitations of their employees. The employees in the railroad industry, fortunately, have a much better voice over their working conditions in certain circumstances than others. The circumstances they have their strongest voice in is after they get hurt. And that's after the fact. So when Mr. Gibbons was ordered to drive this truck across this UP bridge, homemade bridge, and did so, and it collapsed under the weight, and he fell into the ravine and had irreparable, back injuries and other injuries, then he can file a suit. As you mentioned, under the Federal Employers Liability Act, FELA, it's a very unique circumstance where an employee can sue his own employer. In almost all circumstances, states have workers' comp, the feds have workers' comp, and you give up the right to bring a claim. In fact, it prohibits you. It's not even your choice. If they say the employer has workers' comp insurance to pay for your medical bills and to pay some small stipend for your lost wages, that's all you get. So you don't get much of a recovery there, but that's all you get. And if the employer decides to buy that type of insurance, which almost all of them do, you lose your ability to bring a claim against your employer if your employer caused your injuries. Under FELA, which is our railroad area, and as you mentioned, Jones Act for Maritime, many years ago, because of the unique nature of rail and shipping, particularly back in the 1800s, employees were given this protection to be able to bring claims directly against the employer, and the railroad and the shipping industry was not allowed to buy workers' comp to preclude them from being able to bring those claims. So while that's a very effective tool at one level, because when you bring your claims there, you get all your personal injuries. Many times you suffer horrific pain the rest of your life from life-altering injuries. You're able to bring all of those normal types of claims that you could under the law, under other circumstances, directly against your employer. And really then, as with everything else, the employer just does a cost-benefit analysis. How much is it going to cost if somebody collapses a bridge that's a homemade bridge, and how much it's going to cost to pay for them to get them back on the road or pay the widows off or whatever it takes, versus how much would it cost us to build real bridges? And in all these circumstances, in every one of these cases, it's always that analysis goes into play. And again, the union members can't go out there and make the railroad make better bridges. They don't have the legal authority to do that. All they have is a recourse of like, hey man, this bridge that we got here, this old flat rail car, it's a piece of junk. If we fall in it, we're going to sue your ass. That's their only recourse. And fortunately, in this case, Mr. Gibbons did bring suit, because what the railroad industry also does, they try to avoid those lawsuits after the fact. The way they do it is that when they do screw up and they hurt a guy and he can't even go back to work for years, they go to their house, make a personal visit to them, act like they care, tell them they're sorry, and they start paying them some benefits. They're not legally required to pay them like under workers' comp, but they pay them this benefit.
So the guy thinks it's your friend.
They hope that you just take the benefits as they pay you along until the statute of limitations runs.
Which is what?
It's 3 years for railroad. In many circumstances, under law, it's even shorter. But at the end of the 3 years, they pulled the rug on them and said, we're not paying you anymore. It's like, why not? I'm still not able to work. I don't even get that. I said, no.
The right answer is because we don't have to.
It said, you were dumb enough to let us lure you into this trap and we paid you along until your statute ran. And fortunately, in Mr. Gibbons' case, he never contacted an attorney, even though we're designated counsel to the union. He never reached out to us. We were not even aware of his injuries when they occurred. And it was probably, I think, within like 2 months of the statute running before somehow we were contacted and were able to look at it and like, man, we're getting in just under the wire, but we were able to get it.
Let's talk about your successful verdict. What was it, and why was it appealed?
Well, the case was filed in Nevada because the injury occurred in Nevada. They're working track, and again, as I said, it's all over the country. He'd lived in another state, but these guys are all brought in to work a week or two at a time and then go home and then come back and do the same thing on a 7 on, 7 off, or 14 days on, 14 off. So the suit was filed. It was in Las Vegas in federal court. There was a lot of discovery done beforehand. Experts were brought in on both sides. Reinvestigation of the crime scene, so to speak, that was now almost 3 years old because they had delayed the prosecution of the case. But and they argued that we didn't know the bridge was bad. We didn't know this, we didn't know that.
But let me stop you there.
Yeah.
We didn't know the bridge was bad. Wasn't it mothballed in 1963?
Well, first of all, it's not a bridge, but yeah, UP's argument is that we did not know that this repurposed rail car was not suitable for a bridge under these circumstances, nor were we aware that there was any defect in it. That's the main argument.
It's laughable.
Well, it is almost laughable, but that was what they maintained, and they kept their straight poker face on it the whole time. And, you know, the Captain Obvious was in the courtroom, so thought all 12 jurors. It's like, all right, well, this wasn't a bridge, and it wasn't inspected only because you didn't have to. So you don't have a record of reports of the defects in the bridge because there's no inspection program to do that in the first place. There's nothing in the record to show that when you installed it, that it was suitable to do the job that you put it in because you didn't do any testing or engineering to determine what the support level was in the first place. So absent all that, all you have are the two obvious facts. It did not have any utility to even use as a rail car, just to put a boxcar on top of it. So if it can't hold a boxcar safely going down the railroad track, what makes you think it can take a big dump truck full of ballast and go across it? It's oxymoronic to say we can't even put a flat car and back on the line and just put a box from a 18-wheeler on it, but yet we can put a big dump truck with 100 pounds of rocks on it and run that across there. It's like, do you understand some basic rules of science here?
Of thinking.
You could go back if you ran a laser from one end to the other. Again, these are pretty long, but if you run a laser line across both ends, it became very obvious that there was almost a foot dip in that bridge. So even a one is, you should never have used it for a bridge. It wasn't built for it, it wasn't designed for it, or anything else. 2 is, if you're going to use it, do some engineering on it. You didn't do any of that. 3 is, for whatever reasons it was mothballed in the first place, most likely due to exhausting its lifespan and bowing. That bowing was still there and probably worse over time, and it was visually observable. If you'd have done anything, you could have just run a straight line string across there, you would have seen that bow. So you took no proactive measures to do anything, and you're using the lack of evidence that you did, and you're trying to use that against the plaintiff. You're basically saying, there's no evidence to show that we knew this. Well, there's no evidence to show you knew this because you didn't do anything that would create a paper trail. There's no inspections. There's no testing. There's no nothing. And that was their argument at trial. Unfortunately, the jury saw through all of that and said, playing ignorance of the facts is not going to be an excuse of the reality.
Right. You got an award of $1.5 million for pain and suffering, right? Mental anguish, was that?
Yeah, it was 1.5 million. You know, Mr. Gibbons was in that truck when that bridge collapsed and the whole thing went down into the ravine. And it jammed his back severely, compressed the vertebra. He had ruptures of the disc spaces. So you're never fully rehabilitated from that. Even after surgery and stuff, your back never restores. He's in a very difficult type of work. It's heavy-duty, hard work. And returning to that at any point is always going to involve some additional levels of pain. Those disc spaces, even after surgery, continue to degenerate over time. So he'll have an old man's back as a young man and just have to tolerate it and deal with it the rest of his life.
Now, the appeal was on the economic loss that he might suffer as a result of his injuries, right? Originally, it was, I think, $1.5 billion, correct? And they appealed that aspect of the award, correct?
Generally, a focus of the appeal was on the attack of individual items of damages. There was a general attack of the lack of sufficient evidence across the board on the liability of the railroad for using that repurposed flat car as a bridge.
It's like saying to the jury, you don't know what the hell you're talking about.
Yeah, they basically said, we get to use it, and if we don't have to test it, which we don't under the law, we haven't done anything wrong. So they tried to argue that the lack of any federal or state oversight that mandated testing means that they don't have any liability or any duty. It's like you still have a generic duty to just not be negligent. And the jury saw that and said, yeah, you're not violating a particular statute or rule because there is no statute or rule. You get to build your service road bridges out of whatever you want. You can make them out of hay. There's no law that says what you got to make them out of. But if somebody gets hurt because you used a piece of crap material for your bridge, you're going to be legally responsible for it.
Right, and you settled the case finally, that aspect of the economic damages, right?
We did.
Confidentially.
Well, first of all, the jury award was exponentially larger than what they tried to settle for out of court. And there's a confidentiality order that's in place regarding the final outcome of the case. But the jury verdict is public record. And the jury verdict was in the neighborhood of $4 million. And that's a typical, fair, and appropriate amount for this type of an injury with this type of long-term health implications, medical bills, et cetera. So it's not an uncommon value for a case that we get of this type under these egregious facts. But that aside, on the appeal, one of the technical issues that caused us some concern was the manner that the jury was calculating the future lost wages without consideration to reemployment and stuff. So that became a technical issue on appeal that we thought we could negotiate as part of an overall settlement, and we did. We got a very good final disposition of the case that took care of all the client's needs and concerns, and it was enough under the facts to get the case resolved.
Okay, well, congratulations on the case, and thank you for being here.
Absolutely. Thanks for having us again.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.